My lord, with all respect, my lord. Item number 1, my lord. Can it be any day next week, my lord?
Hey, Harry. List খান করবো লিস্ট খান Okay. At first, we will take up the Parshad matter. So,
My lord.
on the request of Mr. B.K. Mahajan, Learning Council for the appellates. Yes, MS Bhuya. The appeal be listed after a week on a date to be fixed by the office.
Highly obliged, my lord. Obliged, my lord.
MS B. Bhuya, Learned Senior Counsel and Additional Public Prosecutor to the respondent number. Response date has exceeded to the request.
Can it be next week?
After a week,
My lord.
My lord, I am extremely sorry, my lord. Item number 4, my lord, I couldn't inform it prior. Maybe adjourn for the day and maybe after 2 weeks, my lord, if possible.
okay. Mr. B.M. Deka,
Yes,
Learned Counsel for the appellant has sought listing of the appeal after 2 weeks, as the prayer is not seriously objected to on behalf of the learned. MSB Bhuya, Learned so and so. The prayer is allowed, list the appeal after 2 weeks on a date to be fixed by
much
the
obliged.
office.
May it please, Your Lordship. Lordship, I beg to mention item number 2, as my senior is on legs, in court to Your Lordship, doing the hearing matter, as that matter will take long.
Okay. Mr. Das? Okay, MS
M. Zomanpui.
M?
M. Zomanpui. I'll write it.
Learned
down.
Counsel appearing for Mr. B.D. Kumar, Learned Senior Counsel for the appellant, and Mr. D.K. Das, Learned Senior Counsel and Standing Counsel NI for assisted by P.K. Darji, Learned Counsel for the respondent number. Respondent NI are present. MS so and so, Learned Counsel appearing for Mr. B.D. Kumar has paid for when after a week,
Lordship, can it be after 15th August?
after
15th August.
15th August. Yeah. Yeah, after 2 weeks. Huh? List the case accordingly after 2 weeks.
Obliged. Your
Prayer is allowed.
Partner together for hearing, item number 8.
E2 division mention matter asil.
My lords.
Yes.
Lordships, primarily, while parting with the matter yesterday, Lordships had made a specific query as regard to what is the juristic position with regard to 164 statements as in the present case, which is Lordship, which is a 164 statement of a witness, which subsequently that one witness while coming and deposing before the court has not stuck to his version. Under such situation, what would be the value of such a 164 statement? And possibly, in fact, in order to have that statement, that 164 earlier statement, to have any value before the proceedings or in the actual trial, what ought to have been done or what would be the remedial measures for either of the parties, my lord. So, Lordship, I have placed a few judgments before the Honorable Court, which dates back to Lordship the earlier 1972. Lordship, I have not placed Tehsildar Singh because Lordships have already perused the Tehsildar Singh copy I have not placed, my lords. Lordship, the first judgment I placed is Ram Kishan Singh versus Harmeet Kaur and another. This is a Lordship division bench judgment of the Apex Court.
One.
My lord, sorry. First is the Ram Kishan Singh versus Harmeet Kaur Lordship. This is a division bench judgment of the Apex Court from 1972. Specifically, Lordship, paragraph number 8 deals with the 164 statement and its value thereof. 1972, 3 SCC 2809. Lordships, paragraph 8. A statement under section 164 of the Code of Criminal Procedure is not substantive evidence. It can be used to corroborate the statement of a witness. It can be used to contradict a witness. The first information report in this regard. So in this regard, report was considered by the session judge. Any special consideration of the statement of Hathura Singh under section 164 of the Code of Criminal Procedure would not have produced a different result by reason of the conclusions of the session judge as to rejecting the oral evidence of Nihal Kaur, another witness, Harmeet Kaur and Hathura Singh as unreliable, untruthful, and unworthy of credence. So this Lordship primarily deals with as to what is the value of a 164 statement in a trial, my lord, that it cannot be relied on as a substantive evidence. Lordship, the second judgment, which deals with more elaborately, this is a division bench judgment of the Allahabad High Court, Lordship, 1991, SCC Online, Allahabad, 1006. Lordship, here, paragraph 11, Lordship, it deals with the genesis, Lordship, as to, in fact, prior to independence also, as to how the concept regarding the 164 and its uses in the trial proceeding as in like the present case would be. Lordship, paragraph 11. The trial was held when the new Code of Criminal Procedure, the present code, had come into force. The wordings of section 164 in the new and old Code of Criminal Procedure with little changes are the same. As early as Manik Ghazi versus Emperor 1942 judgment, a division bench of the Calcutta High Court has held that the statements under section 164 of the code can be used only to corroborate or contradict the statements made under section 145 and 157 of the Indian Evidence Act. In Brijbhushan Singh versus Emperor, the 1946 judgment, and another 1946 judgment, Muhammad versus Emperor, the Privy Council has also observed that the statement under 164 of the code cannot be used as a substantive evidence and which can only be used to contradict and corroborate the statements of a witness given in the court. Similar observations as made in the two cases below were made by the Privy Council in two other judgments. The findings, Lordship, it was also held by the single bench of the Himachal Pradesh Judicial Commissioner's report that a statement under 164 of the code cannot be used as a substantive piece of evidence. In State versus Hathura Singh, 1960 judgment, division bench of the Allahabad High Court itself observed that the statement under 164 of the code cannot be used as substantive evidence. So the findings, Lordship, on the basis of analysis of these judgments, the division bench of the Allahabad High Court in paragraph 12 reached the conclusion that the above catena of cases goes to show that where the witnesses do not support the prosecution story in the court, then their statements under section 164 of the code cannot be used as substantive piece of evidence. In this case, the learned judge has erred in using exhibits this and this as substantive piece of evidence. There was no evidence at all on the basis of which the learned session judge could come to the conclusion that the appellants had actually committed the crime.
Yes.
This is the second, Lordship, the findings, Lordship, after reading paragraph 12, Lordship deals with the same scenario as we are faced with, my lord. Then, Lordships, coming to another judgment which deals with the 164 aspect, as well as, Lordship, on the factual part, as a coincidence, it deals with another aspect which the learned additional public Lordship, my senior colleague, had put forth yesterday, that is with regard to the circumstance of recovery. That, Lordship, is coincidentally, Lordship, covered in this case as well. So, Lordship, with regard to the earlier statement, it is paragraph number 6, my lords. This judgment is of the Guwahati High Court. Lordship, Malkisuddin versus the state of Assam.
Yes.
Paragraph number 6, my lords. Next, we come to two vital witnesses, namely PWs 3 and 4. PW3 is Rahina Khatun, the mother of the accused. Both the families, namely the family of the accused and the deceased, are related. The prosecution has declared PW3 as a hostile witness, and in cross-examination, this witness has brought out certain contradictions in her evidence, as deposed earlier by her before the police, as well as before the magistrate, both 161 and 164 lordships. Referring to those evidence, the prosecution cross-examined her, but most unfortunately, it does not appear whether those contradictions are to be accepted either under 162 CRPC or under 164 CRPC. No formal statement was exhibited, nor there was any evidence to the effect as to whether the contradiction at all by the help of the prosecution. Now, Lordship, these earlier judgments, Ramcharan, which have already been discussed in the Allahabad High Court, these are again discussed, primarily reaching to the conclusion at the next page, my lord. Next page, first paragraph. 6th, 7th, 8th line, my lords. 8th line of the penultimate page. As held by this
Yes.
60, where it was held by the Supreme Court that a statement under section 164 Criminal Procedure Code is not a substantive evidence. It can be used only to corroborate the statement of a witness or to contradict him. Merely because the Sessions Court has taken into consideration the statement of a witness under section 164 Criminal Procedure Code, the High Court cannot direct retrial by setting aside the order of acquittal when the order of acquittal could not be said to be against the evidence or in disregard of evidence or in violation of the principles of criminal jurisdiction. Then, Lordship, here, paragraph 7 deals with the factual aspect, Lordship.
1 minute. Yes.
Yes, madam. So paragraph 7, in this case, two circumstances were put forth. Here, the allegations, the accused was the husband of the deceased victim. The first circumstance which the prosecution tried to rely on was that the dead body was found in a paddy field. However, the prosecution case was that the offense, that is of the killing of the deceased, took place inside the kitchen. So first 10 lines, Lordship, deal with that circumstance, that the accused appellant, who was the husband of the deceased, dragged the body outside. But to that effect, Lordship, there was no independent witnesses apart from the police. So in that aspect, I'm not reading out the entire lines. I'm coming directly to the Lordship dao. Here also, incidentally, Lordship, the instrument being alleged is a dao again. Lordship, the 15th line of paragraph 7, 15th line. The next submission of Mr. Goswami is another circumstance which is more strong to prove the guilt of the accused is the discovery of the dao, which according to prosecution was recovered by the investigating officer from the house of the accused. Of course, we do not get any evidence to the effect that the dao was stained with blood while it was recovered from the house of the accused. We are unable to agree with the submissions of the learned public prosecutor. The reason being that there is no clear evidence by any independent witness that the occurrence took place inside the kitchen of the accused and that the dead body was dragged to the PW road by the accused. In absence of any other corroborative evidence, we are unable to hold that there is any connecting link, at least to show the alleged offense to have been committed by him. Connecting, Lordship, the recovery to the accused appellant, my lords. So these three judgments, Lordship, in the light of Tehsildar Singh, Lordship, have gone through again. So, Lordship, in our case, what had happened was that, Lordship, the primary statement, whether, Lordship, out of their own free will, but by following due procedure, it was recorded before the learned magistrate court. Now, when they came and deposed before the court, and possibly when their version did not match to the earlier statement, then, Lordship, to an extent, yes, it can be taken that the chief, to an extent, is corroborating to their 164 statement, to the extent that maybe not in complete details that this person has attacked with this, that person attacks with that.
164, 161 statement can only be used for the purpose of contradiction,
Contradiction.
right? So far as 164 statement is concerned, it can be used both for the purpose of contradiction or for corroboration.
Corroboration, my lord.
So standing alone, a 164 statement, because it says for the purpose of corroboration.
My lord.
So
My
there
lord.
has to be some substantive evidence,
Yes, my lord.
and it can only corroborate. It
Corroborate.
cannot stand alone
Yes, my lord.
that there is a 164 statement.
Right.
Other circumstances corroborating 164 statement. No,
164. No.
the other way around.
Other way around. Yes, my lord.
164 statement can corroborate.
Yes, my lord. That can be the support or my lord. Apologies.
164 statement cannot be taken as milepost, then other evidences corroborating it. There has to be substantive evidence.
My lord.
This is the way.
That is the way, my lord. So here, my lord, when maybe if we consider also to a certain extent that in the 164 they have elaborated, here they have stated that they know the accused person and they saw these all the persons, maybe not in details, that were assaulting the deceased. But then what happened, lordship, in the cross-examination, this was demolished by the defense by stating that by shaking the credibility of the 164, wherein, my lord, the deponents themselves have stated that that was given under as per tutored by the police. Then, my lord, if at all the remedy was available to the prosecution, of course, my lord, law cannot be remediless to either the parties. Then, my lord, while exercising section 145 of the Evidence Act, and with due permission of the court under section 154, where one's own witness can be cross-examined, then, lordship, either the witnesses could have been brought to their path by refreshing their memories with the 164 given the opportunity, because, lordship, in order to contradict someone's statement, the opportunity has to be given, be it a witness, be it a accused. So that opportunity prosecution could have availed that you have stated this earlier. That part, lordship, was not done. And once it is foregone in trial, lordship, there is no other remedy available, lordship, to rebuild it. And again, another manner, lordship, even if that was done, another lacuna stood, which was the fact that the 164 statement was taken as tutored or coercion, which was allegedly done by the police. Then, my lord, when the IO came for his deposition, it was open to the prosecution in order to make their these two witnesses cross-examination unreliable. The IO could have been examined to the extent that you had not tutored them, and the witnesses whom you took for recording of 164 statements were done following due procedure, and those statements were voluntary. As lordship, these remedies available were foregone. So that makes, lordship, the testimony of PW1, which forms to be the sole basis of conviction in the state case, to be an unreliable one. So, lordship, that is my submission with regard to the evidentiary value of the deposition of PW1, on whose evidence the accused persons have been convicted. In this regard, lordship, I have submitted one judgment as to what is the evidentiary value of such a witness. Lordship, may just give me a little bit. Lordship, this is the judgment of 2009 3 SCC 391, Jarnail Singh versus State of Punjab. As to it, factually, it is same, my lord, 302 matter, but the question is, what would be the value of such a witness's testimony? Lordship, the relevant paragraph is paragraph number 26, my lords. 25 deals with the factual background as to reaching to the ratio in paragraph 26. Paragraph 26, it is no doubt true that conviction could be based on the sole testimony of a solitary eyewitness. But in order to be the basis of conviction, his presence at the place of occurrence has to be natural, and his testimony should be strong and reliable and free from blemish. This conclusion was reached by the Honorable Apex Court, and the basis was laid on an earlier judgment of the Apex Court of 1976, Chauhar Singh versus the State of Haryana, the paragraph 4 of which is quoted under paragraph 26, my lords. So my lord, sole witness, yes, my lord, at times can be the basis because it is the quality of the evidence which matter rather than the quantity.
Hmm.
But my lord, that witness's deposition has to be reliable and blemish free, unlike PW1 in the instant case, lordships. So lordships, the findings of the trial court, lordships, specifically drawing your lordship's attention to paragraph number 80, where lordships of the paper book, my lord, sorry, at page number 71, that is, these are the conclusions, that these conclusions being reached by the trial court to an extent are acceptable, my lords, but attaching that these conclusions or, my lord, the persons involved were the appellants, that lordship, there is no chain of evidence to direct that effect. That she had died and the death was homicidal, that is established probably, my lords. But attaching that, my lord, the rationale which the court has reached at paragraph number 85, that possibly is perverse, my lords. Again, not based on reasoning or the evidence, because the testimony of PW1 could not have been relied on by the court. And to this regard, lordships has already pointed out, my lords, yesterday, that paragraph 65 of the judgment, my lord. So this is a lordship completely presumptory on the part of the trial court, my lord. And such presumption and presuming that they have been reached, accused has access to them, my lord, presumption cannot be out of thin air, lordships. Presumption has to be based on certain facts. So this analogous observation of the trial court at paragraph 65, my lords, is not based on any concrete material, which possibly led to paragraph 85 and the subsequent finding of the appellants guilty, my lords.
Yes, madam.
Lordship.
1 minute, madam.
Yesterday only I have made my submission.
Oh, 1 minute.
Lordship.
The learned counsel sitting here, the other, it may not be possible to take up the other appeals if somebody is waiting. Because so we'll be dictating this order. It will take time. If you have any request, give it to the court master. We'll consider. Yes,
Yesterday made my submission, my lord, as regards circumstances which goes against the appellant, my lord.
circumstances.
3 circumstances, and I'm only be relying on one judgment as regards the seizure of articles from the possession of the accused person. 2007 9 SSA 315 by Tokali citizen.
Yes,
Lordship para 19.
para 19.
Some of the circumstances which need to be highlighted are.
Wait, I am not going to 19. Last page, okay.
Some of the circumstances which need to be highlighted are recovery of the gold ornaments of the deceased as well as the weapon used in the crime.
Good.
The blasted
19.
para 19.
19, where are you reading from?
This one 2007 9 6315.
This is SCR.
Then
Huh?
it will start from some of the.
What is the name of, what is the name?
Gezaganda
Okay.
Somaya.
Okay,
Where you're reading it from?
Para
the AIR.
19. Yeah. This is
I think the
SCC.
photocopy is not matching with the paragraph.
Yeah, so I'm,
Start.
it will start from some of the circumstances which need to be
some of the
highlighted.
circumstances. In the middle or later part or earlier part?
Between, it's paragraph 9.
Paragraph will not do.
Yes, it will be in between, my lord.
Yes.
Some of the circumstances which need to be highlighted are recovery of the gold ornaments of the deceased as well as the weapon used in the crime. The bloodstained clothes of the appellant were also seized. Prosecution has relied on the evidence of PW 6 and 12 to establish its stand about the recovery. PW6 is the goldsmith who was called for testing and weighing gold ornaments. He admitted that he accompanied the police officer for recovery of the ornaments from the accused, but resiled from certain parts of the statements made during the investigation. PW2 specifically stated that the appellant led the police. Lordship, these parts are not there. Discovery is not there. But since Lordship, they could not give any explanation in 313 how it came in possession of the those weapon. Lordship, adverse presumption can be drawn under section 114 of the Evidence Act. Lordship, PW12 specifically stated that the appellant led the police and Mahazar witness for recovery of the articles, namely gold chain, MO10, bloodstain clothes, that is MO14 of the accused. These, along with clothes, were sent for forensic examination. The evidence of FSL officer on his report equally established that the bloodstains were there. Section 114 of the Evidence Act 1872 has also application as held by this court in JP Anand vs. DG Bafna and Azil versus State of TN. In the absence of explanation of the accused as to legitimate or origin of their possession of articles belonging to the deceased, keeping in view of the time within which the murder was supposed to have been the time within which the murder was supposed to have been committed, and the body found, the articles recovered from the possession of the accused, an inference can be safely drawn that not only the accused was in possession of those articles belonging to the deceased, but also committed murder of the deceased. The articles belonging to the deceased were in possession of the accused, but in our case, articles were not.
There were many situations. FSL report,
Those are there, but
blood
I'm
stains.
emphasizing on the
There is a
witness part.
recovery of clean dowel and clean hammer.
That is there, but no explanation. They admitted it to
Why
one trade.
clean hammer, clean, nothing connecting link? And that question, everybody was put the same
Same
question,
question.
stereotype question. And everybody was asked, that was recovered from your house.
So they
Whereas
said yes.
only from one accused out of six, from his house, the dowel was recovered. From another one, hammer was recovered. And those were, I would say, clean. So he did not feel the necessity of sending it for serological examination. So where is
And
it
in
coming?
IO's evidence, I for inquest was also done, but I didn't check the
Uh-huh.
records, my lord. Inquest was also done.
Inquest.
this is
Now,
not-
what is the evidence value? It is like same. FIR and 164. Much lesser than that.
It was not exhibited neither. But I have not gone through the records, but in his evidence, it has come. He did the inquest.
Purpose of inquest is whether it is a case of natural death or suspicious, unnatural. Then accordingly, subsequent steps. So your
Nothing
submission,
more to submit, which I submitted yesterday.
so that mere suspicion that remains as a suspicion that the person, the disease was hacked to death or was on the suspicion of which. It remains in the realm of suspicion
Suspicion.
only.
Committed the crime.
Who committed the crime? That has to be proved beyond reasonable doubt. Okay. Take your seat. Korean lilac. No question. Right, Cora? Because the fatality lies in not declaring PW1 and PW2 as hostile, and thereafter taking permission from the court to cross-examine and make an effort to bring him on their original stand.
Right.
এই মহিলাটা খালি দিয়ে ওদের সৎফল, এই যে ধারে ধারে খাতার মধ্যে দিয়ে আছে। Take your seats, please. The is a sale is made. To a judgment. In this criminal appeal, comma, preferred from jail under section 383, comma, Code of Criminal Procedure 1973, comma, to a judgment and order dated 30/04/2021. Passed by the Court of Learned Additional Sessions Judge within bracket FTC, comma, Vishwanath Sariali. In sessions case number 304 of 2012. Full stop. By the judgment and order dated 30/4/2021, comma, the আগতে লিখি দিব trial court লিখি দিব the learned trial court convicted the 6 accused persons is 49 আছে, huh? Namely 1 2 3 4 5 6 who faced the trial, comma, for the offenses under section section 302 read with, comma, Indian Penal Code, read with, section 148, comma,
148.
IPC.
Charges were framed under 147 as well.
Conviction.
Conviction 148 and 302, lordships.
IPC. And all of them have been sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000 each, comma, in default of payment of fine, in default to pay the fine, comma, to undergo simple imprisonment for another 6 months each for committing the offense under punishable under section 302, comma, IPC. Full stop. The accused persons are also sentenced to suffer rigorous imprisonment of 1 year and to pay a fine of rupees 5,000 each, comma, in default of payment of fine, comma, to suffer simple imprisonment for another month each under section 148, comma, IPC. Full stop. It has been ordered that the sentences are to run consecutively. Para. The investigating machinery was set into motion after institution of a first information report by one Soma Orang on 12/11/2011 before the in-charge, comma, Jinjia Police Outpost against before that so and so Full stop. As per the said FIR, comma, in the said FIR, comma, Soma Orang as the informant had inter alia alleged that his co-villager, comma, Badhna, Badhna, Orang, armed with weapons and accompanied by the 5 accused persons, comma, named therein, comma, took away his wife, comma, Birsa Orang, telling that a particular matter was to be discussed with her. Full stop. The informant further alleged that the said accused persons, comma, out of old grudge, comma, assaulted his wife in a together and killed her by hacking on various on her person. Full stop. After thereafter, comma, they carried the dead body and left it at the door of the house of the informant. Full stop. Para. On receipt of the Ajar, comma, the in charge, Zinji outpost, registered a general diary entry. White Zinjia Outpost General Diary entry number 232 dated 12/11/2011 at 11 a.m. and forwarded the FIR to the officer in charge, comma, Bihali Police Station for registering a case under proper sections of law. Post of comma, while entrusting the investigation of the case to one Hoben Sondonath, comma, a sub-inspector of police, within bracket PW7, comma, attached to the said police station. Full stop. All were arrested.
Lordship, yes. Yes.
Para, during the course of investigation, comma, all the 6 accused persons were arrested post of the IO visited the place of occurrence and prepared a within bracket and prepared a sketch map of the place of occurrence within bracket EXT9 post of 1 hammer, or one how many scissor lists?
Lordship, in total 3 scissor lists. One is for the Dow.
Where is the other one? Okay.
One is for the
One 83.
83.
83, yes. One Dow, comma, one iron hammer, and a number of wearing apparels of the deceased were also seized by the IO in presence of witnesses, while seizure list, MR number 75/2011 within bracket EXT2 on 12/11/2011, seizure list, MR number 77/2011 within bracket EXT7 dated 12/11/2011, and seizure list, MR number 76/2011 within bracket EXT8 dated 12/11/2011 respectively. Full stop. The inquest exhibited? No.
Not on-
IO said anything?
Say-
IO said. The IO, PW7, after conducting inquest proceedings on the dead body of the deceased, forwarded.
Page 22, Your Lordship.
Done. Forwarded the dead body to where it was done? Postmortem.
Page 87.
Which hospital?
Yes.
PW. Doctor 16. Report না আছে, কালকে দেখা নাই।
My lord, appears to be Behali PHC.
Behali Block Primary Health Center, PHE.
Page 91, lordship.
For postmortem examination on 12/11/2011. The postmortem examination of the dead body of the deceased was performed at Behali Block PHE on 12/11/2011, and the autopsy doctor, PW5, after completing the postmortem examination, recorded his findings in a postmortem examination PME report EXT5. Full stop. The prosecution, it is a case of the prosecution that during the course of examination, statements of two of the witnesses, namely, Ramu Urang and Dilip Urang, were also recorded. Under section 164 CRPC. By presenting them before the Court of Learned Judicial Magistrate First Class Vishwanath Sariali on 14/11/2011. Full stop. After completing investigation into the case, Bihali Police Station case number 211 stroke 2011. Within bracket corresponding GR case number 799 stroke 2011, the IO submitted a charge sheet under section 173 to CRBC. Wide charge sheet number 44 of 2012 on 35/2012, finding a prima facie case well established against the 6 accused persons, named in the affair, for the offenses under sections 147 stroke 148 stroke 304, IPC.
You were arrested on 12/11/2011, all of them.
Okay, taken into custody, 12/11. Full stop. At the time of Central Jail, collected. All the 6 accused persons named in the affair were charged-sheeted or different?
Not-
Let us examine,
not
because 2 others were also arrested. Let us see, because our statement will be wrong. Banna was there.
93, my lord.
Somra was there or not? Somra.
So, number 3. the charge sheet.
Omit was there or not? Was there.
Omit is there.
Bablu was there.
There. Pradeep.
Pradeep was there. Hete? Okay.
Yes.
Because 2 other persons, Bhandu and Priya, they were also arrested during investigation.
Not charge sheet.
And when they were released, bail, any
My
idea?
lord, that order is not available because I've said
Uh.
previous bail is there. That is why I
Inferred
inferred that, my lord, they were arrested.
Due to FIR Nasil, any other question? After submission of the charge sheet, the court of learned this. Secured the appearance of the 6 charge-sheeted accused persons before it on 15/9/2012 by issuing summons, as they were already released on bail in the meantime. Full stop. After securing their appearance, the learned court of so-and-so complied with the procedure laid down in section 207 CRPC by furnishing copies to them, full stop, as the offense under section 302, IPC is exclusively triable by the Court of Sessions, the Court of Learned so and so. by its order of commitment dated 15/9/2012, committed the case records of GR case number 799/2011 to the Court of Sessions, Sunitpur, for the purpose of trial. Full stop. As the six succeeded accused persons were on bail, they were allowed to remain on previous bail till their appearance before the learned Court of Sessions on the basis of applications filed by them. Full stop. The learned public prosecutor was accordingly notified. Full stop. Para, on receipt of the case records of GR case number so and so, the Court of Sessions, Sonitpur,
Regarding date of shipment, I've got the order. 13/2/2012. Bail was-
otherwise not disputed.
May not-
Prior to submission of charge sheet, they were on bail. The Court of Sessions, Sonitpur, registered the same as Sessions case number 304/2012 and transmitted the case records to the Court of Learned Additional frame order says transmitted the case records to the Court of Learned Additional Sessions Judge FTC Vishwanath Sarili Trial Court for trial and disposal. Full stop. The learned court, trial court, upon appearance of the six accused persons before it and after hearing the learned public prosecutor and the learned defense counsel and upon perusal of the materials available in the case record, framed the following charges against them, on, 26/6/2013, page 7. When the charges were read over and explained to the accused persons, they pleaded not guilty and claimed to be tried. Full stop. In the course of the trial, the prosecution side examined 7 number of witnesses and they were 1, 2, 3, 4, page 80. Full stop. In order to bring home the charges against the accused persons, the prosecution sides also exhibited 9 number of documents and they were page 80. Full stop. After closure of the prosecution or evidence from the prosecution side, the accused persons were examined under section 303, 313 CRPC by putting before them the incriminating materials emerging from the prosecution evidence. Emerging from the evidence of the prosecution witnesses. Full stop. Their pleas were of denial. Full stop. When the accused persons were asked as to whether they would adduce defense evidence in their support, they answered in a negative. Full stop. After hearing the learned counsel for the parties and after appreciation of the evidence stroke materials on record, the learned trial court proceeded to deliver the judgment an order. Huh?
Not complete denial. Question number.
Where of denial. Where of denial of committing the act of murder. Hmm? Who did ourselves? Proceeded to deliver the judgment and order of conviction and sentence as mentioned here in the post-doc. We have heard Mr. D.K. Boido, learned amicus curiae for the appearing for the accused appellants, and MSB Bhuya, learned senior counsel and additional public prosecutor, assisted by MS R. Chakraborty, M. Chakraborty, learned counsel for the respondent state. Post-doc. Where Mr. Boido, learned amicus curiae, has submitted, has contended that the prosecution had presented two prosecution witnesses, that's PW1 and PW2, as eyewitnesses. But on close scrutiny of their testimonies before the court, it would be evident that none of them were eyewitnesses.
Present at the alleged.
It would be evident as their versions in the first part, their versions in the first part, that is, in the examination in chief, were at variance to their versions in the second part, that is, cross-examination. Huh? Then I will be sure. Full stop. It is his further contention that the learned trial court, while considering their evidence, had erred in law, had erred in construing that appeared to have erred in construing that it was the defense who ought to have confronted page 72.
That one was not confronted, that's why.
Ought to have been confronted by the defense. Full stop. It is his contention that as the if the prosecution, it is his contention that if the prosecution was of the view that these two witnesses had deviated from their previous statements recorded under section 164 CRPC, So the view level, no? These prosecution witnesses ought to have been confronted by the prosecution side and not by the defense side, right? In any view of the matter, it is his contention that in any view of the matter, comma, any statement recorded under section 164 CRPC is not a piece of substantive evidence, and its purpose is limited for corroboration only. For the purpose of contradiction or corroboration only. Full stop. If the evidence of these two witnesses
By the trial court. By the trial court, lordship, that is paragraph
Correct.
55 onwards, my lord. Paragraph 55, page 66, my lord. With regard to those 164 statements,
and again, in presence of insufficient evidence, no? The judgment and order of conviction and sentence cannot be sustained against the accused persons and para par contra, comma, MS Bhuya, learned additional public prosecutor appearing for the respondent. The state has submitted that the informant had clearly mentioned the accused persons as the persons involved in the perpetration of the crime resulting in the death of his wife. Full stop. From the evidence on record, it is MS Bhuya has further contended that from the evidence on record, it has emerged that these accused persons had motive to kill the wife of the informant as she was which she was involved in witchcraft. Full stop. As there were recovery of the alleged recovery of the weapon of assaults, and those are bloodstained cloths
But,
or not?
those clothes were seized from an abandoned place, if you lordship, and is wearing a page 101.
Nothing.
In connection above so and so. Not from the position of the accused person, but weapons have been seized from their position. Weapons have been seized from their position.
And wearing apparel from in abandoned conditions. There is clear indication that it was the accused persons who were involved in the crime. Full stop. Submission nahi. MS Bhuya has further pointed out to the answers given by the accused persons in connection with the recovery of the weapon of assault when they were examined under section 313, CRPC to buttress her above submissions. First of all, we have duly considered the submissions of the learned counsel for the parties and have also gone through the materials stroke evidence stroke materials on record, including the testimonies of the witnesses and the documentary evidence, available in the case records of sessions, case number so and so, in original. Full stop. We have also considered the decisions referred to by the learned counsel for the parties during the course of their submissions, and reference would be made and there will be no full stop. Para. এনেকে যাওঁ প্ৰথমৰ পৰা এটা আছিল প্ৰথমে মেডিকেলটো কৰি লওঁ PW5 নহয় জানো before dilating on the ocular testimony of the other prosecution witnesses, we first turn to the medical evidence available on record. Full stop. Which are in the form of the testimony of PW autopsy doctor, PW5 and the postmortem examination report within bracket EXT
Five.
5. Post of subpara. PW5, Dr. Jugen Chandra De, who was serving as sub-divisional medical and health officer at Bihali Block PHC, on 12/11/2011, performed the postmortem examination of the dead body of the deceased, Birsa Orang, aged about 35 years, in connection with Zinjia Outpost Police General Diary entry number 228. BSNA? Nine. Nalage. In the connection with so and so nalage. Posto. In his testimony, he mentioned about the injuries found on the persons of the deceased. Mentioned about the following injuries. Following injuries. 17,000, 17, A2. A2A. He deposed to the effect that all the injuries were antemortem in nature. Full stop. And the penetrating injuries on the face were caused by sharp pointed objects. Full stop. It was thereafter opined that the death was due to shock and hemorrhage due to the injuries sustained. Full stop. He exhibited and proved the PME report as EXT5 and his signature therein as EXT51. Full stop. In cross-examination, he stated that the age of the injuries were not mentioned in the PME report. Full stop. Alcohol and it was not possible to say about the approximate time when the date of the disease took place. It was not possible to say from the PME report about the approximate time when the death of the disease took place. He clarified that the injuries sustained on the rib injuries sustained by the disease could not occur due to fall on hard substance, as only abrasions could result from falling on hard substances. Full stop. Subpara. In the PME report EXT4, the followings were recorded. Right, yes. Premium review lacerated star di দিব যত না লাগে contain blood, venous, no injury, muscle, Acquisition. From the testimony of PW5 and the PME report, EXT4, it has emerged that the disease sustained one penetrative injury on her face, apart from bruises with abrasions over back, chest, and abdomen. Post-op. There were multiple rib fractures on both sides of the chest. Post-op. All the injuries were found to be antemortem in nature. Post-op. The penetrating injury on the face was found to be caused by sharp pointed objects. Post-op. From the nature of injuries sustained by the deceased and the nature of weapon used to cause those injuries, it can be safely concluded that the death of the deceased was a homicidal death. Post-op. Para. Now, next, the question in view of the homicidal death, in view of the nature, in view of the nature of death of sustained by the disease, the question, the next issue which arises for consideration is whether the evidence led by the prosecution, whether the other evidence led by the prosecution during a trial are sufficient enough to link the accused persons, to connect the accused persons with the crime. Post-op. Para. কোনখন থাকিল তেনে পাঁচ গ'ল নহয় জানো, পাঁচ গ'ল, বাকী এইকেইটা আননেচাৰী কোনটো আছে, 3 আৰু 6 নাই ন, 5 নাই ন, সিহঁতৰ এইকেইটা কৈ লওঁ। PW3 was a co-villager নেকি, was a co-villager, and he knew the deceased. তাৰ আগতে লিখি দিওঁ, এইটো পিছত ক'ত সোমাই দিওঁ নাজানো। It is submitted at the bar that during the course of the investigation stroke trial, during the pendency of the case, the informant, Soma Orang, expired. Full stop. Fair enough. That's a PW3. Comma. Raghunath Orang was a villager, was an inhabitant of the same village, comma, number 3, Police Sumani, as that of the informant within brackets he's diseased. And the accused persons. Full stop. In his testimony, comma, he deposed that he came to know, no, one Katiram Orang, within bracket not a witness, told him that Birsa Orang was killed by some unknown person. Full stop. He, on receipt of my information, comma, he went to the house of Birsa Orang and saw her dead body lying on the ground. Full stop. PW3 was a witness to the seizure list, comma, MR. MR, Exhibit 3 Exhibit 3.
Exhibit 2, Lordship.
He is exhibit
Lordship,
2.
this will be 2, this will be 2, sorry.
Page.
Page 83, Lordship.
83. He was a witness to the seizure list, comma, MR 75/2011, whereby page 83 jabo, huh? A dhow measuring 11 inches long with a bamboo handle was seized on being by the IO PW7 on being produced by Shivani Orang, comma, wife of Samora Orang, comma, Samora Orang, comma, who? Samora Orang. Who was an accused? Who is the Samora Orang Kurishula, page 83 does, huh? And he, stop, PW identified his signature in EXT. 2 as EXT2, full stop. At this stage, the prosecution side sought permission from the court to cross-examine this witness after declaring him as a hostile one. Full stop. During cross-examination by the prosecution, comma, PW 3 denied a suggestion put to him by the denied a suggestion that he stated before the IO that Soma Orang, comma, which Soma Orang? Soma Orang, comma, the husband of the deceased, comma, told him that the accused persons killed Birsa Orang. Full stop. When PW3 was cross-examined by the defense, comma, he stated that police recovered the dao from the house of the accused, Bablu Orang. And he did not know to whom the seized dao belonged to. Full stop. He further stated that he did not know anything more about the occurrence. Full stop. Para PW4, Parul Borua. Deposed to the effect that C was the scribe of the FIR EXT4, which was lodged by the informant, Soma Orang on 12/11/2011. Full stop. She identified her signature as EXT41 in the said FIR. Full stop. She further deposed that she wrote the FIR as per the version of the informant, Soma Orang, and as asked by Soma Orang, she lodged the FIR. Full stop. She further stated, PW4 further stated that as told by Soma Orang, she wrote the name of the accused persons in the FIR. Full stop. In cross-examination, PW4 stated that the informant, Soma Orang, was sent to her house from the police station for writing the FIR. PW4 further stated that she did not have any personal knowledge about the incident. Full stop. And full stop. The informant, Soma Orang, was illiterate and he only put his thumb impression in the FIR. PW4 further stated that as she was not told what objects the accused persons had carried with them, no mention was made about it in the FIR. The informant did not disclose about any kind of previous grudge harbored by any of the parties. Full stop. PW4 also stated that there was no mention about the time on the night when the victim was, the body of the victim was left at the house or at what time the informant came to know about it. Full stop. আৰু এটা থাকিলে কোনোবা PW6, Lothu Rang was a co-villager and a neighbor of the informant and the accused persons on the incident, PW6 stated that on the incident, like PW 6 deposed to the effect that on the date of the incident, comma, he went to tether the cattle in the school field near his house. And then he saw gathering of many people there. Full stop. Going there, comma, he saw the dead body of the deceased lying there. Full stop. He further stated that he had no knowledge as to how Bisa Orang, how the woman died. Full stop. Cross Para. From the testimonies of the above prosecution witnesses, comma, PW 3, comma, PW 4 and PW 6, comma, it has emerged that none of these witnesses had witnessed anything, witness the incident of assault on the deceased by the assailants. Full stop. They were neither witnesses to the taking away of the deceased from our house, nor to the assault to Kulwe, nor edit হয়ে যাওয়াটা, body to edit হয়ে যাওয়াটা, and nor to the leaving of the dead body of the deceased in the house of the informant. Full stop. Their testimonies are not of any assistance to the prosecution side to bring home the charge of murder by IPC. By unlawful assembly. Unlawful assembly নাকি? Unlawful assembly হয় না। And participation of the accused persons in an unlawful assembly. Full stop. Whether their testimonies would corroborate the testimony of the remaining two prosecution witnesses for the purpose of examining that whether the testimonies of these witnesses would corroborate the testimonies of the remaining two witnesses, that is, PW1 and PW2. We would now turn to the testimonies of PW1 and PW2. Full stop. Para. PW1. PW1, Ramu Urang. Wherefrom you are saying he was nephew?
Lordship, in his 164 statement, he addresses the deceased as his mummy.
Oh, that will not go. 164 will not go. In his testimony before court, he
No,
said so,
Lordship,
no?
not the relationship, my lord.
Ramu Urang, who was a resident of village number 3, Police Homoni, deposed to the effect that he knew the accused persons. Full stop. He stated that the incident took place on one evening about 1.5 years ago. Full stop. On that day, he stated that on that day, the accused persons assaulted Birsa Orang with dao and hammer. And as a result, Birsa Orang died. He further stated that Birsa Orang was assaulted as he was suspected to be a witch. Full stop. PW1 stated that he gave his statement earlier before the court and exhibited his such previous statement as EXT1, which is signature therein as EXT11. Full stop. PW1 also stated that he was a witness to seizure of a dao by the seizure list, EXT2, and he's identified his signature therein as EXT21. Full stop. He also identified the dao as MAT EXT1, which was seized by the seizure list, EXT2. Full stop. Your signature to all.
Lordship.
This Ramu
Lordship.
was seizure witness to all the seizure lists.
No, Lordship doesn't appear to be in the iron hammer, my Lord. The
Ramu
iron
was
hammer-
there. Dao was there.
Yes, Dow he was there, my Lord. Dow at page number 80,
Where the other one? Seizure list?
page number 83, he is, my Lord.
Ah.
84. Orang is there. Page 84, yes, and other Caesar list, Lordship, is at page 99.
He was
Witness
not the
Dao.
witness.
He is not a witness, Lordship.
And also to PW1 also identified two material exhibits, MAT EXT1, a hammer, MAT EXT2, and the wearing apparels of Birsa Orang, MAT EXT3, though he was not a
Caesar,
witness
to the Caesar of
to the seizure list. Whereby those material exhibits were seized.
the
Close
hammer and the sari.
Para. In cross-examination, para sub-para. In cross-examination, PW1 stated that he came to know about the incident 2/3 hours after the incident had taken place. He learned about the incident. He stated to have learned about the incident when he came home after working as a daily wage earner. PW1 further deposed that he neither saw nor heard as to how many people were present at the time of the incident. He stated that he did not know where from the police brought the material exhibits, and he did not know when the same were seized. He further stated that he was not aware about the contents of the seizure list, and he put his signature in the seizure list out of fear for the police. As regards his previous statement, PW1 stated that his statement in the court, he gave his statement. He gave his such statement in the court as tutored by the police, because they told him that if he did not do so, he would be punished. Supper. On reading the testimony of PW1, reading both parts of the testimony of PW1, that is, the examination in chief part and the cross-examination part, it is evident that the two parts are at variance to one another to a substantial, in a significant manner. Full stop. From the cross-examination part, in the cross-examination part, PW1, from the cross-examination part of PW1, it is discernible that he was not an eyewitness to any of the incidents which connected to the death of the deceased, that is the wife of, or death of the deceased, Pirsa Orang, who was the wife of the informant, Soma Orang ne ki asil? Soma Orang. So according to him, he became aware of the incident only after occurrence, only after 2-3 hours only after 2-3 hours after the incident. Full stop. On the material exhibits also, as regards the material exhibits also, his testimony was that he was not aware about the place of their seizure. Full stop. PW1 claimed to be also claimed that he did not know about the contents of the seizure list. Full stop. As regards the previous statement, his previous statement made before the court, which he exhibited as EXT1, PW1 in his cross-examination had stated that he made such statement before the court as tutored by the police, and after he was given the treat that if he did not do so, he would be punished. Full stop. when with such part of the, no, stop, when the first, his deposition in the examination chief part is considered, comma, purely one stated there in that PW1 in the in that part, comma, stated about the occurrence of the incident and the assault, about the assault on the deceased by dowel and hammer by the accused persons. Resulting into the death. Full stop. PW1 in the examination in chief part did not specifically depose to the effect that he was an eyewitness to such incidents. Right? Right? Did not depose specifically. Right? Did not depose. Full stop. In such, in the face of such, on the face of such testimony of PW1, it cannot be said that the testimony of PW1 can be accepted as an eyewitness to any of the events preceding, comma, attending and succeeding the death of the deceased events. কারণ পরপর লই যোৱা কোনো নাই তাৰ প্যারা comma, as claimed by the prosecution side, comma, as claimed by the prosecution side. PW2, comma. বহিব লাগিব নেকি? বহিব লাগিব নেকি? এইটো ইয়াতে এইটো কৈ দিওঁ, এটা দুইটা এইটো PW2 আনি পেলাই তাৰপিছত এইটো লটো একেবাৰে চলে। PW2, comma, Dilip Orang. Like PW1, comma, also an inhabitant of the village, comma, Puli Sumoni, wherein the disease and the accused persons also used to reside. Full stop. PW2, comma, in his examination in chief, comma, deposed to the effect that he knew the accused persons and he saw the accused, comma, Batna Orang assaulting Birsa Orang to death on suspicion that Birsa Orang was a witch. PW2 stated that he gave his statement previously in the court PW2 denied a suggestion this is a leading question, I think. Leading question in examination in chief. Is it not?
Yes, madam.
Huh?
Maybe could have
Answer was suggested. Answer was suggested.
Could be the
That
defect in your
prosecution, in
object,
examination in chief.
or maybe lordship, it is not reflected that with
Uh-huh.
permission of court, he was cross-examined or.
That I
maybe
don't
in
know
some manner,
that,
but-
see the record, whether it is there. Orders it,
While examining.
18
PW2.
September 2013. Can you suggestion হয়ে গেছে? Suggestion cannot be put by prosecution unless he is declared to be hostile.
Yes, ma'am. But the hostile access to definition word does not exist. So
No,
seek
they-
permission of the court and cross-examine your own witness.
That is
Only one order sheet, 18/7.
9.
All accused present, PWs examine and it is and
Discharge, Nikki, madam.
discharge after cross is to summon to
Other
PWs.
PWs.
Other.
No, nothing is
PWs.
issue a summons to PWs fixing 611 for further evidence.
No permission.
Conspicuously comma PW2 denied a suggestion given to him by the prosecution that in his statement, in his previous statement given in the court, comma, he stated that the accused, comma, Banda Orang, Badhna, Orang, along with the other, all the other accused persons present in the court had committed the offense. And he had falsely deposed that he did not mention their names earlier. Full stop. PW2 denied another suggestion of the prosecution side, comma, in his examination in chief, comma, to the effect that he told the police that the accused persons assaulted Birsa with dao and stick. Full stop. The previous statement of PW2, no, he exhibited his previous statement. Recorded under section 164 CRPC as EXT3, with his signature therein as EXT31. Poster. Para. Subpara. In his cross-examination by defense, comma, PW3 told that, deposed that it was the villagers who told him about the incident. And he came to know about the incident only when he came home in the night after doing walks in the daytime. Full stop. PW3 stated that he did not see how many persons had gathered at the place of occurrence and who were those persons. Full stop. He specifically stated that he did not see who killed Birsa Orang and how she was killed. Full stop. PW3 further stated that he was only questioned by police on the following on the day following to the date of incident. And he told the police that he did not witness the incident. Full stop. But full stop. The police brought him to the court for recording his statement. And after teaching him as in what manner such statement was to be given in the court. Full stop. PW3 further stated that he mentioned the name of Banna Orang
This is probably PW2, my lord. Here.
টু এখানে PW2
Earlier
PW2
occasion.
এখানে ঘুরে এখানে PW2 in the court because the villagers told him his name. Prosto. Fair. On a close perusal of the testimony of PW2, comma, it can be seen that though in the first part of his testimony, comma, that is in the examination in chief part, comma, he claimed to have witnessed the incident of assault. His testimony in the second part, comma, that is in the cross-examination part, comma, he declared to be himself to be a hearsay witness, as he claimed that he was told about the incident at a later point of time. And thus, comma, he did not see how and why, who and how Birsa Orang was killed. Full stop. If only notwithstanding notwithstanding the deviation, notwithstanding such deviation, comma, if only for arguendo, assuming for arguendo, comma, if only first part of the testimony of PW2 is looked at, that is the examination part, examination part is looked at, comma, it can be seen that in that part, comma, PW2 had only implicated one accused person, comma, namely Patna Orang. Full stop. It has not emerged from the materials on record as to why the prosecution side had put suggestions to PW1 when he was examined in chief. Full stop. Fair enough. it has been strenuously contended by the on behalf of the state that the the prosecution witness, PW2, in his previous statement recorded under 164 CRPC within bracket EXT 3. Where is that? Had clearly implicated all the 6 accused persons by mentioning the time and date of the incident of assault and the weapons of assault by which the deceased was assaulted. In such it has thus been contended that the such previous statement of PW1 which was consistent with the FIR lodged against them on 12/11/2011. Previous statement, it was date to DD1. Fourteen 11. Cannot be discarded as they, as it demonstrates the strong circumstance, demonstrate about a strong circumstance about the involvement of the accused persons in the crime. Full stop. Such circumstance, along with the fact that the deceased had to meet her date. No, full stop. It has been also contended that the disease was suspected to be killed. No, disease was killed as he was suspected to have practiced witchcraft. So all these circumstances go to show that the accused persons were involved in the crime. Posta. Para. We are in respectful disagreement to the above contention advanced on behalf of the state. Full stop. Yes, enough. It is too as well settled that a statement recorded under section 164 of the code, statements recorded under section 164 of the code are not substantive evidence in a case. Full stop. Hey, evidence explanation. Uh, it is the evidence given in the court under oath which has the ultimate sanctity, and it is for this reason, the same is called substantive evidence. Full stop. Statements under section 161 CRPC. It is a settled proposition that statements under section 161 CRPC can be used only for the purpose of contradiction, and statements under section 164 CRPC can be used for both corroboration and contradiction. Full stop. It has been clarified that so far as the statement of witnesses recorded under it has been clarified in R. Saji versus State of Kerala, reported in 2013, 14 SSC 266, that so far as the statement of witnesses recorded under section 164 CRPC is concerned, the object is twofold, in the first place, to deter the witness from changing his stand by denying the contents of his previously recorded statement. Para 27 semicolon. And secondly, to tide over immunity from prosecution by the witness under section 164 CRPC. A proposition to the effect that if a statement of a witness is recorded under section 164 CRPC, his evidence in court should be discarded, is not at all warranted. So as the defense had no opportunity to cross-examine the witnesses whose statements are recorded under section 164 CRPC, such statements cannot be treated as substantive evidence. Full stop. It has been full stop. Fair enough. Fair enough. During the trial, when the prosecution witness PW2 when he was cross-examined, deviated from his statements recorded under section 164 CRPC, exhibited during his cross-examination in chief as EXT three, as EXT 3, and also from the text and tenor of his testimony given during examination in chief, the prosecution did not seek any permission from the court in order to 157 degree. $54. Permit his cross-examination under 154, section 154, comma, Evidence Act. Poster. At this juncture, comma, it is relevant to mention that the learned trial court had had made an observation that the statement given by PW2, the previous statement given by PW2 and the section 164, comma, CRPC were not contradicted by confronting him with such previous statement. When at the time of his testimony before the court, in compliance with the provision laid down in section 145 of the Evidence Act. Gustav. Observing so, comma, the learned trial court proceeded to observe that from the evidence of PW2, comma, it appeared that he had supported his evidence was fully corroborated with his previous statement recorded under section 161 and section 164 CRPC. তহসিল লাড্ডু করেছিল হ্যাঁ It is pertinent to mention that a previous statement of a witness recorded under section 161 CRPC cannot be used for corroboration of a prosecution witness. As it can only be used for can be used by the defense for contradicting a prosecution witness. Right? Full stop. So far as the learned trial court's observation about receiving corroboration from the observations regarding testimony of PW1 receiving corroboration from his previous statement under recorded under section 164 CRPC is concerned, comma, we find that such observation was in clear ignorance of the testimony of PW2 given in his cross examination by the defense. Full stop. In such view of the matter, comma, no, para. এইটা খালি যে কইছিল এটা কই দিব লাগিব প্রিভিয়াস স্টেটমেন্ট গুজরাট ভাই যেগুলো আছে মনত নাথাকে ভাইবোৰ চব বেলেগ বেলেগ আমাৰ চিপৰ্টটোৱে মনত থাকে ৰশ্মি মনত থাকে বাকী ভাই একো মনত নাথাকে As it has emerged that the testimony given by PW2 in the evidence in chief part was at serious variance to the testimony given in the cross-examination part comma, thereby, comma, resulting in two contradictory persons of the same witness and there was existence of a previous statement of this witnesses previous statement recorded under section 164 CRPC, which was uh, conformity which was consistent with the case of the prosecution, comma, we are of the considered view that it should have been, it should, that it was the prosecution side who should have sought permission from the court to cross-examine PW2. No, who should have to confront this witness with his previous statement recorded under section 164. Full stop. There were materials to indicate that this witness had gone back on his previous statement and by presenting a completely different person in his cross-examination, comma, which has made him an unreliable witness. No, made his, no, which has made, which has clearly dented the credibility, his credibility. Full stop. In this connection, in Satpal versus Delhi administration, versus Delhi administration, reported in 1976 1 SSC 7-7, the Honorable Supreme Court has elucidated about the purposes of cross-examination of a witness by the party which itself called him, in the following manner, paragraph 42. The fallacy underlying this view stems from the assumption that the only purpose of cross-examination of a witness is to discredit him. Semicolon, it ignores the hard truth that another equally important object of a cross-examination is to elicit admission of facts which would help so and so, so and so. Para 42. Para. In this connection, the following observations made in the case in Lohia Bhai, Sogan Bhai Thekar versus State of Gujarat, reported in AIR 1964 SC 1563, are also of relevance and import. এইটো কিন্তু এই ৰবীন্দ্ৰনাথ দেৰ ভিতৰত আছে মোৰ অৰিজিনেল জাজমেন্টটো নাই Para. As observed in Lohia Bhai, Shagan Bhai, Thekar, Supra. The prosecution witness in the case in hand, PW2, in his examination in chief, appeared to have conformed to what he stated earlier in his statement recorded under section 161 CRPC and stroke or section 164 CRPC. But in the cross-examination, introduced statements in a manner contradicting in effect totally what he stated in the examination in chief. Full stop. But the prosecution side hearing did not choose to cross-examine this witness by taking permission from the court under section 154, Evidence Act in order to make effort to bring this witness to revert back to what he has stated earlier in his statement recorded under section 164 CRPC. Full stop. As was he? as the same full stop, thus, comma, we are in we are not in a position to agree with the observation made by the learned trial court that in the absence of confrontation, comma, the learned trial court was left with no option but to accept. It is 2 or 1? 85?
This is one lordship.
Kind
One
of.
fifty-one, which is freaking out.
Something is wrong. It should have been 2.
Two also to an extent is same, my lord. But the learned trial court here has placed reliance on one lordship. However, what lordship have observed in the preceding paragraphs, that will be holding good for two as well.
Ah,
Those also are correct with respect to two. But trial court has made the ruling with regard to one.
In the absence of not confronting the witnesses like PW1
One and two both.
or PW2, their depositions made in the examination shift were to be accepted. We had disagreement will question, no? Okay, full stop. We'll end the last para. We have some meeting 4:45. But don't expect Monday. Order will be Monday.
Yes,
Matter would be listed, my lord.
Not
Well,
matter
lordship
will be
will-
listed.
lordship will
Pass
pass
the
the-
order. Result will be acquittal. On benefit
yes,
of doubt.
nicely argued.
Yes, yes, yes.
Appreciate.
PPI.
He is also fairly, my lord.
MS Bhuya is fair.
Yes,
Oh, obliged.
you learned from her, my
এইখিনি
lord.
ভালকে এইখিনি ভালকে থৈ দিব হা ভালকে সামৰি থৈ দিব এপিল ইজ এলাউড
Lordships, obliged.